Good evening, this is John Milburn, Laws 11057 Introduction to Law. It's Week 10, Term 3, 2015-2016. Let me start with some comments in relation to the third assessment piece. This is, to be honest, the first time that I've asked students to attend to this particular task, and I hope that you find it enjoyable and not too daunting. I'm very keen for you to experience a few different things as part of your study, and it seems to me only logical, given the online format, that I invite you to provide me with some online material. Part of it is to assess your communication skills. Part of it, your technical ability to work your way around some research, online legal research project. And as you would have seen in the discussions on UCREW, I'm very pleased for you to think of any topic and present the material in any way that you see fit. You can go very broadly with your material and cover in short detail a lot of different types of legal research, or you can zero in and use one platform, and within that platform, if you want, you can provide a commentary or, if you like, a legal research critique on a particular topic. So it's very broad parameter, and the way you do it is you record your session, you'll need to upload it, and then in a Word document, you provide some commentary and then you include in that Word document a link that I can use to access your material. Now, in the past, when I've done this type of thing for other subjects, for example, alternative dispute resolution, some students leave the settings on private, so I can't see the material. So you'll need to deal with that technical issue to ensure that I can see the material. Maybe email it to a friend and see if they can read it, or try to open it from another computer or something, just to ensure that it's ready to go. I would think that you'll need to go to camera for a while, and I'd also expect that you would at some stage, use a screenshot so that I can actually see what you're doing on screen. Now, you might have realised from the way in which I turn my head that I have two large screens. I find that really useful. Some people have three that really surrounds you. But if you're working off a smaller screen, that's probably more difficult to do. But it may be worth the investment of getting a second screen. All right, so if there are any questions to do with that third assessment piece, please let me know. I appreciate that what I've said is really just expanding on what's already been said in UCREW. I can't go too much further because at least one student has already submitted their work, so I shouldn't go into any more detail than that. Okay, so if there are any questions, please let me know. And as indicated earlier, you can unmute your microphone, ask a question live, or you can use the chat facility and I'll monitor that. In terms of the exam, I just made a few notes to myself. Have a think about the textbook and the reading material generally, but generally in these introduction to law sessions, I like to introduce just an introduction to some substantive law. So think about criminal law and contract law will be the two hints for this time. In terms of criminal law, typically, if I'm going to ask a question about that, it will be a question as if you're a first-year lawyer and you're in your first week and you get a call from the watch house and a client of the firm wants some urgent advice. I mean, if nothing else, remember, of course, that the general rule, the golden rule is you don't have to say anything unless there's very good reason to do so. I would urge you not to say anything to the police and go from there. So that's the default position. But there are a number of other things, and I think we covered that. Please let me know if that's not the case. So you'll recall from our previous discussions, commentary in relation to the sorts of discussions that you might have with your client and the police officer. The other thing that I might do is ask you to consider something about the question of bail. Now, I'm just going to go to gallery view for a moment. So if you're a bit camera shy, you can mute your cameras. I hope you don't, because it's always nice to see who else is in the class. So if we could do that. So the other thing that we often do is I will often ask about a bail application. So hypothetically, you're in a position where you're representing a client in circumstances where police wish to object to ongoing bail or a grant of bail rather, and you need to argue some of the things. So just off the top of your head, what do you think a magistrate would be interested to know in terms of a bail application? What's going to be important to a magistrate to consider? Feel free to unmute your microphones or come in using the chat facility.
Whether there a flight risk?
Exactly, thank you very much. That's a great answer. A flight risk, that's really important, because the number one thing about bail is to ensure that they attend when required to do so. So what would you, as a lawyer, put forward to deal with issues relating to a flight risk? What are the things that might convince a magistrate that a person is not a flight risk? Far away.
Surrendering their passport.
Surrendering their passport, yes, that'll stop them more than likely going overseas. So that could be a relevant factor. What else is there?
Reporting conditions.
What was that, sorry?
Reporting conditions.
Yes, thank you, Matt. Reporting conditions, that could be a good one too. What else would a magistrate want to know about? A person is,
whether they're a risk to community?
If they're a risk to community, yes. And Heidi mentioned the criminal history as well. So I guess you'd look at the criminal history to determine if there have been previous instances where the defendant failed to appear when required to do so. So that past history, the criminal history, might be a guide as to future conduct. So flight risk is a person who owns real estate and has lived in a certain location for a long time more likely to be a flight risk than someone who doesn't. So local support for and services, local personal standing in the community. Thank you very much. Are they on bail for other offences? That's an important aspect because they may it may reverse the onus as well. If they've breached bail and they're on bail for an indictable offence and they're charged with another indictable offence, the whole onus changes and the defendant must establish that it's reasonable to get bail as opposed to the other way around. Guarantor, says Luke, or surety as we call it. So a surety is a person who puts up money as, if you like, a guarantee for the attendance of the individual. Matt says risk to themselves or the community. That's a really good point. That's a very valid point. And what sort of risk are we talking about? Risk of, what would be a suitable word there?
Risk of reoffending.
Reoffending, thank you, Matt. That's the word I was looking for. Reoffending, so number one condition on bail is turn up when required to do so. Number two is don't commit any offences while you're on bail. Okay, if they've got a drug or alcohol problem, so what are some of the ways that we can deal with that issue? The magistrate says, well, these offences allegedly occurred when the person was adversely affected by illicit drugs. What could you say to deal with that issue to satisfy a magistrate that it's appropriate? Random testing by police, urine tests. Yep, I like that. So we're being creative. We're doing some brainstorming now in the criminal law context. Rehab, yep, that may be appropriate. So the sorts of things that you've really covered a lot of the field already. Now, I use a checklist when I'm doing bail applications. So why not start to create a checklist for yourself? I mean, maybe you could even refer to that in your examination if this question comes on board. So the magistrate wants to know that the person will show up, being established in the community, having somewhere to live, having a job maybe, staying with family support. All of that's really important in terms of the sense of this person will turn up when required to do so. Rehab, reporting conditions, no alcohol, no illicit drugs, they're all valuable things as well. All right, so maybe do some extra reading, just some wider reading in terms of bail applications, and I'm sure there's lots of material freely available from various sources over the internet, etc. So thank you for that. So now we've covered, I guess, the two aspects of criminal law that may be relevant in terms of the examination. Contract law. Did we cover a bit of offer, acceptance, communication? Did we do that previously? We've done a bit of that. All right. So, again, usually it might be a case of someone comes to you in the first week you're in a law firm. They wish to buy some real estate. They present a contract to you. What are the things that you need to do? Well, two things really. The first is understand what it is that is needed from a legal perspective to create a contract. And just to refresh, that's offer acceptance, communication of that acceptance back to the person who made the offer, consideration, which means there's some exchange of value, if you like, or detriment, but for the most part we're talking an exchange of value, money for real estate, and an intention to enter into legal relations. That's probably the fifth element in general terms for a contract. I think we briefly talked about a deed. A deed is where you don't need the last two. But for a contract, and that most of the agreements that you'll come across are contracts, you need those. Now, when it comes to real estate, there are a couple of special rules. One is that the contract must be in writing in relation to real estate. That's under the Property Law Act, as opposed to a verbal contract or an oral contract. So we tend to use the words verbal and oral interchangeably. If you go to a takeaway store and you order a hamburger and you exchange money, well, there's no written contract, but it's still a contract, isn't it? It's still a contract. It's just a verbal or oral contract. But when it comes to real estate transactions, it needs to be in writing and it needs to be signed by the party that is going to be affected by that transaction. So there's a special rule or two there. And remember, of course, that when it comes to contracts, there are other disciplines that loom large, such as consumer law, and that might be a relevant aspect of it as well. So if you are able to do some little bit of wider reading in terms of acting on behalf of a party that might be interested in purchasing real estate, that could be useful as well. And I'd like you to sort of bear that in mind. Sometimes this won't be on the exam, but some years I deal with issues to do with wills and powers of attorney. I'll just touch on that briefly. A will is separate to a power of attorney. Power of attorney is a document that gives someone power to make decisions and sign documents on their behalf while they are alive. It comes to an end on death. A will, of course, is something which becomes effective upon death. So the power of attorney takes us this far, and then on death, we then look at the will. Power of attorney is out of the picture. With both of those things, you need to be aware of the issue of capacity. We've talked about capacity a few times during the course. Have a look at the definition of capacity in the Guardianship and Administration Act, Queensland, 2000. I think it's in the schedule from memory. But definition of capacity is essentially that the person is able to understand the nature and effect of decisions, is able to communicate their decisions in some meaningful way, and is able to do so freely and voluntarily. They're kind of the standard tests, subtests of the overall test of capacity. And I may have mentioned that I do a lot of that in my QCAT work, where I'm hearing adult guardianship matters. So have a look at capacity. I mention it because that issue flows over everything that you might do, and it might always be an issue of consideration. During the course, we've talked about legal issues versus equitable issues. And legal is, really from that black letter law. These are the things that came into existence on paper through legislation, and very literal type black letter law. That's where the legal side started. Equitable side started when the courts of equity, through the Chancery and the King originally, King or Queen, decided things on fairness, and the two merged together. But it's not a total merger, because many of the equitable remedies are not available, for example, in the Magistrates Court. Examples of equitable remedies are specific performance, which is an order effectively forcing someone to go ahead with the deal. Someone signs a contract to buy property, real estate. The seller, for no good reason, says, I'm not going ahead with it. I've decided I need to keep this real estate. The buyer can sue for damages. That's money. That's a legal remedy. Or the buyer can sue for specific performance, which is an order effectively forcing the seller to go ahead with the transfer. So if you want an equitable remedy of that nature, you need to go to the district court. You can't get that type of order in the magistrate's court. You can't get that sort of order, you know, in QCAT. But it's interesting, in the jurisdictions, it's not necessarily clear cut in terms of the dollar values and also the available remedies. For example, in QCAT, we have unlimited jurisdiction, which we share with the Supreme Court, and we are able to make equitable orders, such as declarations and in injunctions, which aren't necessarily available in other jurisdictions, such as the Magistrates' Court. So do a little bit of reading about the jurisdictional limits and the type of orders that can be obtained in different tribunals and courts. Okay, I know I'm moving very quickly, and I'm looking to see if everyone's keeping up. Are there any questions, comments? All good? All right. I hope you don't mind that I've left you on gallery view so we can see each other. All right, so understand just a few basic equitable principles, injunctions, declarations, specific performance, things of that nature, because there might be a question on that. Now, of course, you know there'll be a question on separation of powers, but in the context of the exam, think of separation of powers a little more widely than just a straight, this is what it is. Think of it in terms of how it applies for delegated legislation and maybe for judicial activism, things of that nature, where it's still dealing with separation of powers, but with a little bit of a twist. Delegated legislation, of course, is where Parliament delegates to the executive power to effectively create laws through that delegated legislation regime. Local governments, for example, make laws, bylaws, regulations all the time. They have no original power to do so. There's no power other than what is delegated to it under delegated legislation. All right, so again, if there's any questions, please stop, ask a question, use the chat facility, otherwise I'll press on at a fast rate. But we're getting there. Think about, for the exam, access to justice. Think about what are the impediments, really, to people having access to justice. Think about your communication skills. Think about your resilience skills, your self-management skills, your reasoning skills, reasoning by analogy, etc. Think of, IRAC or CIRAC, whatever you want, whichever one you prefer. So they're all part of your reasoning skills, your legal reasoning skills. So think about communication skills, self-management, resilience, reasoning, all those sorts of things. Now, one thing we've touched on from time to time, but we haven't covered specifically, is the solicitor's conduct rules. You need to know those. This is the publication which is available from the Law Society, but you don't have to buy that one. You can get by without it, but if you can afford to buy that, you've got time to do so, I'd recommend that. It's a very good publication, and it's annotated, so it's got cases in it as well. I mean, have a look at undertakings, for example, which is on is Rule 10, relates to undertakings, and that's in the context also of conflicts concerning clients, former clients. Communication between clients is important. So undertakings is Rule 6. So think about the general rules. For example, Rule 3 or 4 deals with the paramount duty to the court and the administration of justice. Think about that in the context of the duty that you otherwise have to your client. And I might put in a practical situation and say, well, here's perhaps what you might do for your client, but here's the wider issue. Client instructions, confidentiality, they're really important. Undertakings, as I mentioned. I've got a video that relates to undertakings and the new practice directions, or the legal information guide that's come out recently. So I'd have a look at those things as well. All right. So, are there any questions about that quick overview in relation to what you might expect on the exam? All good? Okay. Just on judicial activism, a couple of comments. That is, of course, where the court, probably the High Court, reforms the law in circumstances where Parliament has not. So, Mabo, the recognition of, or the statement that terra nullius was no longer applicable, that's a prime example of judicial activism. Think about where people might criticise judicial activism on the basis that it works retrospectively, perhaps, or that judges shouldn't be lawmakers, they're not qualified, they're not representative of the people, and it offends against the separation of powers issue. All right, well, let's move on to some other aspects of what I want to cover tonight. I've given you an indication that I wanted to brainstorm tonight. We've already done that in the context of criminal law. Just moving now through some notes that I've prepared for myself, and these undertakings, I've covered that. Okay, so in the context of giving advice, a client may want some advice in terms of anything. It might be to do with a neighbourhood dispute, it might be to do with a debt dispute. So you need to think about how you approach the client in terms of providing that advice. And it can be wider than perhaps you might think, certainly wider than I was taught in law school, which was really just, here is the law, apply the law, and that's it. So I think of it in terms of holistic advice. I'm not talking alternative medicines or alternative, legal remedies, or ADR, alternative dispute resolution, is very much a part of this holistic advice that I talk about. What do I mean by that? You've got to think about different options that might be available. So the first thing that comes to mind is when a client comes to you asking advice in relation to a neighbourhood dispute, debt dispute, or whatever, it's sort of like a legal triage. You're thinking of lots of different options, lots of different ways that this might work for this client. But you do need to think about the personal circumstances of the client. For example, the advice that you give to a 20-year-old may be very different to the advice that you give to someone who is 90 years of age. Now, I'm interested in your thoughts. You may say that's not a valid comment, but to my mind, it may be appropriate. Also, so take into account the intellectual, the socio-economic, age, cultural factors, risk factors. You may need to ask some questions to determine this. And also the advice that you give to someone about complex litigation, let's say a defamation claim, may be very different if you're talking with a person who is borderline intellectually disabled, as opposed to a commercial operator who owns a business and has been an employee for many years. And the ethics side of it comes in as well, to my mind. So if, for example, you have a person with borderline intellectual disability wants to take on a case that is arguably unmeritorious, it might be unrealistic, or it might be unremunerative, it might, say a defamation case. And this person says, well, I can pay, I've just received $1 million compensation payment. You've got to ask yourself, is it appropriate to now embark on what might be $200,000 litigation claim just because the client has the money? So there are issues to do with the advice you give, the advice in relation to prospects, but also the ethical issues as well. And this is what I mean by this sort of holistic approach to it. Think in the wider scheme. And you need to tailor the question to the particular legal problem. Now, in thinking about the legal problem, you may have to think a bit wider and ask a few more questions. For example, in the context of a debt dispute, just put your thinking caps on now. What are the sorts of questions that you think you might have to ask a client if they come in and they say, I want you to pursue a debt for me? So fire away, unmute your microphone if you wish, or use the chat facility. What are the questions that you ask yourself when a client says, I want you to chase a debt? Was there a contract? Very good. Yep, so what's the source of the claim? Is it a documentary debt or is it otherwise? So is there a contract? Do you have a contract? Two of you came in with the same answer on that one at the same time. Okay, so who was the debt with? Family. That's a really good question because that may affect the advice that you give. You may be much more inclined to promote the alternative dispute resolution factor. Matt says the value of the debt, how much is the debt, came in at the same time, Matt and Luke. So why is that important? The value of the debt, how much it is your advice going to be different if we're talking a $100 debt as opposed to a $100,000 debt? Heidi says jurisdiction. That's great. That's a good answer. So obviously to provide the advice, you must know the jurisdictional limits. Is it going to be economical? I like that answer. Thank you, Leanne. What else is there? Different jurisdictions, higher court fees. Yep. Different level of risk, cost associated with it. Why else is the value of the debt important? Okay, so it's sort of a cost-benefit analysis. What other questions do you need to ask yourself? So a client says, yes, it's a $20,000 debt. It's not related to family. Can you help me? What other questions or advice do you need to consider? We're really talking about the broader questions that you need to ask initially. I want you to chase this $20,000 debt. It arises as a result of a breach of a written contract, and it's with someone who is not a friend or relative. Have you tried ADR? Thank you very much, Luke. Has the personal company gone into bankruptcy? That's a really good question. You're going to look a bit silly if you've spent $20,000 in legal fees chasing a $20,000 debt only to find the company doesn't exist anymore. So thank you for that. Those figures were not realistic. We'll make it if you've spent $2,000 chasing a $20,000 debt only to find the company is bankrupt. What other questions do you need to ask? It's $20,000 we're chasing. It's in a contract. It's not someone that you're related to. It's not a company that is, it's not a person who has gone into bankruptcy or a company that has gone into insolvency or liquidation. Who is it? Who is the debt with? Exactly, that's a really good point. So you've got to find out, is it a company? Is it an individual? Are they disputing the amount as owed? That's a really good question too, because that might colour your advice. It might encourage you to go to litigation or to alternative dispute resolution. I'm not saying one or the other, but it might tailor the advice because you know what you're getting in for. Okay, what about the when? Now, always ask the when, the who, the what, the where, the why questions. All those W questions are great in this context. So what is the history of communications? Understand the full picture. When was the contract made? That's a really good point, Matt. Thank you. What does that matter? What if they say, oh, it was 10 years ago? Is that important? Is there any written communications in relation to the debt? So 10 years ago, would it still be enforceable? Yes. So statute of limitations may be relevant. What about the where questions? Where? Why is that relevant? Where? Was it in Australia? Yes. Was it international? Yep. So Luke and Rusty coming in with the same thing, because that may affect the decision. Say, yes, it's a $20,000 debt, and it's the Crown Prince of an African nation that owes the money to me. That may have a bearing on your advice, yeah? So the international sphere, or even the state sphere. I mean, are we talking, I said it was a contract. Does it say in the contract that the law of Victoria applies? In which case that may well affect your advice. And again, you've got to think about all those things that might make you look a bit silly if you proceed and march off on a certain thing, only to find that your expectation or your assumption was actually wrong. So you've got to ask lots of those questions. Think about that. Think about that in the context of the exam, perhaps, and ask all those W questions is probably the advice that I'd give you. Okay, also think in terms of different types of remedies. Are we going to litigation? Are we going to self-help remedies? What are the self-help remedies? Can you complain to others that might assist you? I mean, for example, if it's a workplace debt and your client is owed, I don't know, $30,000 in entitlements because, let's just say hypothetically, a nickel mine went broke, then you might ask for assistance from someone else. It may be that other people can assist your client in those circumstances. So there's a whole lot of questions that you need to ask yourself. Is the debt for a legal purpose? That's a really good question, because if your claim is based on an illegality, it may be ill-founded. It may be that you can't pursue the matter because it's an illegal contract. That's a really good point, so thank you for that. Are there previous legal proceedings, says Rusty? Yep, so there may have already been a claim. There might be, you've got to ask these questions to draw the information out from the clients, because clients aren't really very good at pigeonholing the advice and concisely telling you the important material. It just doesn't happen. You've got to draw it out. So you've got to use a bit of cross-examination skills with your own client to be in a position where you can actually advise and assist your client in the right way. So let's think about some of the client support historians here. That's a really good point. Thank you, Leanne. So let's think about some of the non-litigation options that might be available to a client. Let's think about the least intrusive first up, the most gentle options that are available to your client that will cost your client the least, will be the quickest, the least intrusive in terms of lawyers and courts and all the rest of it. So what's the first one? Mediation. Yep, even more than that. I'll put that about a third of the way up. Chat with the other party to resolve. I like that. Thank you, Heidi. So letter of demand, says Matt. But oftentimes, I think as lawyers, we forget that simple thing of, well, why not have a chat? Can you make a direct approach? Can you have a chat over a beer or a cup of tea or something? Ask yourself, can the debt be paid? Look, even more basic and probably the least intrusive is the advice, maybe walk away from the debt. Even though the amount is substantial, it's your choice, and if you wish to instruct me to proceed. However, based on the fact that this debt is statute barred and you're pursuing a company that is now in liquidation, I believe you should consider walking away from the debt and writing it off. So that's really least intrusive, isn't it? It's over and done with right now. Then there's the direct approach that we've talked about. And then, Luke, the mediation approach probably comes after that. There are different mediation services. Some are free or minimal cost through the Alternative Dispute Resolution Centre. Others are paid services where lawyers are involved. So there's some of the things that you can consider. Now, think about in terms of who can help. Who can help in assisting your client? Not lawyers, not courts. Who else can help? And this is all part of the holistic advice. So before you necessarily march off and issue proceedings, you've got to say, well, who else can help you to resolve this? Family, yes. Unions, yep, in the right case. Unions, definitely. And it depends. There's lots of ombudsmen, aren't there? There's the government ombudsman, the telecommunications ombudsman, the banking ombudsman, insurance ombudsman service. So ombudsmen might be able to help. Maybe the police, workplace representatives, yep. Fair work, yep, depending on the nature of the claim. Maybe it's the anti-discrimination, maybe it's the superannuation complaints tribunal. Welfare rights may be able to help. So there's a whole range of different places where you might go for assistance. It might be consumer affairs. But assume that your client says, look, I do wish to proceed and I want you to get involved. The first step, and I think someone mentioned it before, letter of demand. So If you're actually getting involved and you're opening the file and you're pursuing the matter, usually you'd start with a letter of demand. Why would you bother with a letter of demand? Why not just go straight to litigation? Can anyone think of a good commercial reason why you would do a letter of demand first? Any thoughts? All right, if I could suggest, sorry?
Cost first and foremost, I would think.
Absolutely, Matt. Yep, the cost associated with litigation. Why not try a letter of demand? It might just work. Sometimes they do. There's another factor too, and that is the letter of demand may work in terms of the money is paid, which is great. But if you bypass that letter of demand, you go to litigation and you issue proceedings, they might pay the original amount and then dispute the costs on the basis that there was no letter of demand. And costs are usually discretionary for the court. And the court might say, yeah, you should have issued a letter of demand, saved all this money. I'm not going to award you costs. You jumped the gun a bit. So the cost to your client, the costs that otherwise might have been claimed from the other side, that's an issue as well. And then, of course, you've got to think about what tribunal, what court you issue your proceedings in. That means you've got to understand the jurisdictional limits and the type of orders that the courts have available to them before you can make that decision as to where you go. All right, well, thank you very much for all that. I hope you didn't find that too draining. And we're getting pretty close to what I wanted to cover tonight, but I'll just press on a bit more. So in the event that your client says to you, look, I want to pursue a debt of $5,000, maybe think about that. I'll put something on UCRU and we can chat about this. So your client says, I want to chase $5,000 in debt. Where do we go for that? What if your client says, I want to chase $50,000? Where do we go for that? The third option is the client says, look, I want you to sue for a faulty refrigerator. It's worth $2,000. What do you do there? How do you deal with that specific issue? Or a client says, I want you to sue for a faulty motor vehicle worth $30,000. Where do you go there? And remember, consumer laws always play a part in these things. And that's why I think as part of the research, I did ask you to find the Australian consumer law as one of the problems. So you've got to be able to find that Australian consumer law. You've got to be able to find, say, the criminal code as well, things like that. And what if your client wants to sue for an anti-discrimination matter? Where do you go for that? So there's some of the things that I'll invite you to comment upon in UCRU. Okay, so next week will be the last substantive week. What I want to talk about is some ADR options, talk about the litigation steps from a civil perspective, and any other general discussions that we might have. Oh, and also importantly next week, I want to do a redrafting exercise. So have your thinking caps on ready to go for that one. Okay, are there any questions from tonight? We'll let you off a bit early tonight. All good? Okay. All right, well, thank you very much for joining us, and we'll see you next week. All the best.